Recently, the Fair Work Commission determined that a dismissal that had no valid reason for the dismissal was actually a fair dismissal. Today, we're going to outline the facts of Murray versus Dangan 2021 and consider if there are any lessons for businesses when it comes to having a valid reason for dismissing an employee. Now, firstly, let's break down the circumstances surrounding the dismissal. The employee had been with the employer since 1999, and the business requested that the applicant take on additional duties. The employee declined this request unless the employer was willing to pay more money, as well as allowing him to work 4 days per week instead of 5. The employee was then invited to a disciplinary meeting for refusing to follow a reasonable directive from the business and issued a warning. The employee asked to resign and gave the employer formal notice of resignation. The employee returned to the meeting 10 to 15 minutes later after having spoken with his wife and asked to be terminated instead of resigning. The company accepted and paid the notice period in lieu of having the employee work the notice period. The Fair Work Commission accepted that while there was no valid reason for the termination, it was not harsh, unjust, or unreasonable, given the fact that the employee invited the dismissal. The Fair Work Commission suggests that even in the event that the termination was found to be unfair, the employee had not suffered any losses, given that the employee's resignation would have run its course, making the total anticipated employment period only run for a further 4 weeks, and the business had already made payment for this period. So what we learn from this case is that where the employee submits their resignation during a performance discussion, the resignation will still stand. The Fair Work Commission recognises that even if the employee wasn't terminated, the resignation would have remained to run its course. We've also learned that where an employee resigns and is subsequently dismissed from their employment, the maximum penalty that's likely to be awarded is to the conclusion of the notice period. Now, please note that as with all dismissal considerations, this is done on a case-by-case basis depending on the individual circumstances. In other words, this is most certainly not a blanket invitation for businesses to invite, influence, or coerce employees to resign as an alternative to termination in an effort to absolve them of unfair dismissal claims before the Fair Work Commission. If you have a challenging termination situation in your business, then we encourage you to reach out to us by visiting ondemandhr.com.au, where one of our experienced consultants can provide direction, not only based on technical knowledge such as what we've covered in today's session, but also based on practical experience representing parties before the Commission, ensuring that our guidance is not only mitigating risk, but also balancing the risk against achieving good business outcomes. So that's all for today, and we hope that you're all staying positive and looking forward to seeing you all in the next update.